Okay.
And scene. Hey, I'm Robert Guest. I'm here with Jose Noriega.
I like the seductive eyes that you just did there, Robert, and thank
Your
you for
dog,
having me.
is your dog in there?
Yes, my dog just walked in. And this
Uh,
is what happens when you work from home. But this is my sweet little boy. Nelson, come here.
are we going to start over? You want to keep with us? You want to roll?
Yeah, we'll just keep
All
with
right.
it.
Me and Jose are doing a couple videos today. One thing we're going to talk about is bond and bail. And so we've been hearing a lot in the news about kind of PR bonds because the governor had an order kind of restricting them in certain cases. But it makes us want to talk about, well, what is a PR bond? And so, Jose, I know you got your dog there, and that's important. But why don't you tell the audience about your dog first, and then what is a PR bond and who gets them and why?
This is Nelson Noriega. So, what happens with the PR bond is the governor is actually being sued by multiple different people right now regarding the whole restrictions of PR bonds. However, sorry, uh, you are still entitled to PR bonds in certain situations, right?
Well, what is a PR bond? Tell the audience that.
PR bond is essentially where you get out of jail for free, and if you don't show back up to court whenever you do have a court date, you have to pay some money. So
and PR means
personal recognizance.
Yeah.
So essentially, the court is saying, "Hey, look, we're going to let you go, but if you don't show back up, then you're going to owe us, $500, $5,000. I've seen some that are $1 million for." Well, if they're enforceable, but
like in Kaufman County too, because they have pretrial services, right? And so people think, well, you get a PR bond, you just get to leave. But can the judge on a PR bond still impose bond conditions? Is that something they can do?
Yeah, so they can still impose conditions of bond, and they can still impose where you have to check in with pretrial services, or we gave a CLE earlier where they could even up your conditions of probation if you get out on a bond there. But realistically, I'd expect some bond conditions no matter what.
And depending on kind of the type of case too, like how serious it is, what the offense is, and that kind of controls or can influence what your conditions are. Like we've seen drug tests for certain clients. We've seen psychological evaluations, all those bond conditions, right? And even up to like GPS monitors or alcohol interlock systems. These can all be bond conditions, and they can also all be PR bond conditions. So nothing stops a judge, even though they're not paying money. I mean, that's the only difference, right? But let's talk about this, because certain kinds of cases, right? We think of as criminal defense lawyers, like, well, you can apply for your PR bond after so much time if the state isn't ready. Why don't you tell the audience about that?
So basically, the state has 90 days to indict a felony case. The indictment is kind of the charging instrument that, lets you go to trial. So what the legislature and via case law has said is that if the state doesn't indict you within 90 days, then you're entitled to a PR bond or a bond that you can make.
Yeah. And
just practically speaking, you're in jail, so you probably can't make any bond.
So you're in, because we use indictment, but and I think it has to do with because the state literally can't be ready for trial within 90 days if you're not indicted. And so our kind of takeaway as defense lawyers is, well, we check and see if the case is indicted in 90 days. And if not, then we feel like, okay, this is going to be kind of prima facie evidence that the state can't proceed, right? Because they're not even indicted. And so certain cases, especially forensics, like drug cases, waiting on the labs can take longer than 90 days. And because they take a lot of court appointments, and you'd have people in jail because they can't make bail or they have a hold or something. And you can go, well, now we can go in and ask for the bail to be reduced. And there's a shorter time limit for misdemeanors. Jose, do you know what that is?
So for a Class A misdemeanor, it's 30 days. And for a Class B misdemeanor, it's 15 days. And so, it makes kind of sense why they did those, just because, maximum punishment for Class B is 180 days. Maximum punishment for Class A is 365 days. So they kind of lowered those.
Yeah, it's lowered the time limit. And I think one of the other reasons, maybe this is it or not, but there's just not that much like forensic work you got to wait on for misdemeanors usually. Like you can file a DWI without having the labs back. I mean, you don't have to, and these are people who haven't been convicted of anything. They haven't had any evidentiary hearing. I mean, literally there's nothing that's been shown as evidence against them beyond a PC affidavit, which, I mean, you don't get to challenge those when they're filed. They just get entered. And so I know because we read social media comments about bail and bond, and people, they have this assumption, I think, well, if you're in jail, you did something bad, and we know you did something bad, but how do you know, like, if you're in jail and you have a defense, if you can't present it or if you can't challenge the evidence? And so if you know someone who is stuck in jail and you want to know, are they eligible for a PR bond, or can we get a PR bond? We offer free consultations, for criminal defense. And you can call us at 972-564-4644 or visit us on the web at guestandgray.com.
Thank you.